Good day, Crime Talk aficionados. We have another great show for you as we head into the weekend. First, prosecutors add another attorney in the Bryan Kohberger matter, and his first job is to tell the defense they're withholding information. Karen Reed's lawyers try again to get her case dismissed before the United States Supreme Court, and we also almost have a jury. Taylor Schabusiness, remember her? Remember that name? She proves why she is a danger to the community. An update on that Texas stabbing case. Was it self-defense? Young thug comes this close to going to prison for the next 20 years. Another teacher doing what apparently teachers do, but this time with a twist. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us anytime on any of your favorite podcasting apps as well. So please go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you're able to do as many background searches on anyone here in the United States as you desire. A report is literally prepared while you wait. You're going to get all types of information as general background information such as telephone numbers, addresses, social media presence, emails, whether somebody has a criminal history, whether somebody's on one of those registries. That's right. You know what I'm talking about. Check them out. It literally could save your life someday. So go to crimetalksearch.com. You're going to be happy that you did. All right. So it is April 4th, 2024. Let's go ahead and open the record. And first on the docket. That's right. The prosecutors have added a new attorney to their team. And the first thing he says is, hey, defense, you're withholding information. That's right. Idaho's former United States attorney has joined the prosecution team in the case against Bryan Kohberger, obviously the man accused of killing 4 University of Idaho students back in November of 2022. Now, according to the most recent court filing, Joshua Hurwitz will serve as a special deputy prosecuting attorney for Latah County. Now, the Latah County prosecuting attorney, Bill Thompson, is still leading the prosecution team, but they're bringing in some extra attorneys. This is a big case. Hey, the defense has 4, maybe 5 attorneys if you count the appellate people, right? Got to make it fair. Anyway, Hurwitz was originally appointed by former President Joe Biden in 2022, and he left the top job there for the United States Attorney's Office in Idaho in February of 2025 at the beginning of, obviously, President Trump's administration. It's not uncommon for appointees from the previous administration, particularly the United States Attorney's Office, to resign. They are political appointees. They are not career prosecutors at that point, so to speak. And I can tell you, everybody that was at the helm here, even the acting United States attorney, nice guy, I've known him for years, left and is now back at the Denver District Attorney's Office as a prosecutor, but is more of an administrative role. A little surprising that this guy would actually come back and be a trial attorney. Now he's been the former United States attorney. Usually they move on to bigger and better things, but hey, everybody's got to make a living, right? Anyway, like I said, one of the first things he's asked to do, or he signed his names to, is a motion saying the defense has not fully disclosed all the data behind their 2 mental health experts. Now, the state requested additional materials, including the test results and the facts supporting the expert conclusions, to allow their own experts time to review and prepare to rebut the defense expert's opinion. The supplemental discovery request specifically refers to evaluations by the forensic psychiatrist, Dr. Eileen Ryan, and neuropsychologist, Rachel Orr. And guess what? We have those for you. So I went and took a quick look at Mr. Hurwitz, who is now the former United States attorney. Now, Mr. Hurwitz was born in 1981, and he was, like I said, the former United States Attorney for the District of Idaho from 2022 through 2025. So he's 44 years old, has kind of a baby face here. Anyway, he started working as an associate back in 2006 at Paul Weiss, Rickfline, Wharton, and Garrison in New York City. And then in 2007 and 2008, he served as a law clerk for Judge Naomi Rice Buchwald at the United States District Court for the Southern District of New York. He was also an associate at Covington and Burlington in Washington, D.C. from 2012 to 2022. He served as a assistant United States attorney for the District of Idaho, and during his tenure, he also was the prosecuting team member for the Aryan Knights, a white supremacist gang that was active in Idaho. And he also served as the District of Idaho's coronavirus fraud coordinator. In 2022, the former President Joe Biden announced his intent to nominate Hurwitz to serve as the United States Attorney there in the District of Idaho. His nomination was sent to the Senate in 2022, and he was ultimately approved. He resigned February 13th of 2025. A little surprised he didn't go back to work at big law. This is the kind of guy. He has a bachelor's degree from Stanford and a Juris Doctorate from Harvard Law School. He's a Harvard man, ladies and gentlemen. And just think, now he's back to filing motions, just like all us little street lawyers, so to speak. Like I said, everyone's got to make a living, but I'm really surprised, though, they haven't, he didn't go and get a job back at big law, at Paul Weiss there in New York City, and do that corporate compliance work that they pay $1,000 an hour to do. So anyway, like I said, his first motion as a special deputy prosecuting attorney was to say that the supplemental request for discovery disclosure goes through the normal stuff. Basically, it's their motion to seal, but it's here they have the undersigned request, the continuing request pursuant to this. Now, while the first supplemental request applies to all of the defendant's expert witness, the specific basis for this request is that the defendant's disclosure for the reports of the forensic psychiatric evaluation by Dr. Eileen Ryan and the neuropsychological evaluation by Rachel Orr appear to be incomplete. The reports do not appear to be accompanied by all the results and tests conducted as part of the examination. The facts and data for the opinions contained in the report, as such, they do not afford the state a complete opportunity to consider the substance of such testimony and prepare for rebuttal through its own experts. Accordingly, they request immediate production of the underlying data, or there will be consequences. From United States Attorney to the number 3 on the trial team there, reduced to filing motions. Oof, that's got to be tough, going back to Harvard to tell everybody that you're drafting your own motions. How the mighty have fallen, so to speak. Anyway, welcome to the team there, Joshua Hurwitz, former United States Attorney, former big law, Stanford and Harvard man. Maybe this will be your big break. We'll have to wait and see. All right, next on the docket. Miss Karen Reed, her attorneys try once again to get her case dismissed. Potential jurors have been called up for questioning one by one as the selection process continued Friday there in Massachusetts in regards to the trial for Karen Reed. Her retrial, I guess I should say. Many of the jurors are being excused right after their number is called and before they can even walk up to the judge's bench. As of close of business on Friday, 5 men and 5 women were selected for jury duty during the 3 days of impanelment there at the courthouse. Now, the court seeks to seat 16 jurors, of whom 12 will end up deliberating and 4 will serve as alternates. Now, a group of Massachusetts residents has filed a lawsuit challenging the expanded buffer zone that the judge put in place around the courthouse. The judge said the zone is necessary to prevent outside influence, interruption, and distraction. And the plaintiff said that the zone infringes on their rights to free speech. In the filing Thursday night, Reed's lawyers also asked the United States Supreme Court, that's right, the big one, the SCOTUS, the Supreme Court of the United States, to intervene in her case, arguing, once again, double jeopardy, that she has lost not only at the trial court level in the state, she's lost at the appellate court level in the state, she's lost at the district court level in the habeas petition, and the chances of the United States Supreme Court hearing this issue, I would say, are about slim to none, ladies and gentlemen. Slim to none. But I have a solution. When I get through the story, I'm going to tell you what my solution is, all right? Anyway, they asked the Supreme Court to consider a unanimous but unannounced decision by a jury following trial that the prosecution failed to prove the defendant's guilt beyond a reasonable doubt. Anyway, like I said, Reed's lawyers have argued that the jurors came forward after the first trial to say they had agreed on acquittal for 2 charges and that they were only deadlocked on the third. Now, in other news, Reed's team asked for the judge to give them a full list of potential jurors because they want to do as much research on them as they can before they actually get up there. Anyway, the defense says they're not being shy about it. They want to research potential jurors before there's any additional questioning. Well, the judge allowed the attorneys access to the daily list, but ordered the teams to not have any contact with the potential jurors, and they can't disclose the results of their research, and only one non-lawyer from each team may participate in the research. So now Ms. Reed has 5 attorneys in the courtroom with her, including Victoria George, who served as the alternate juror in the first trial. Now, she was tried on charges including second-degree murder last summer, but obviously that ended in mistrial, which is why we're going to do it again. Now, after the jury sent 3 notes indicating a complete impasse, jury selection for her second trial began on Tuesday. Now, there were 74 new potential jurors that were brought in and questioned, and attorneys selected 3 more for the final pool, which over the 3 days makes for a total of 10. Like I said, 5 men and 5 women. The jury selection has turned out to be a somewhat difficult process, as everybody expected, as the vast majority of the jurors have indicated each that they have at least heard of the Reed case, with another majority of those also indicating that they have formed an opinion about the case one way or the other. Anyway, so I have a solution for Karen Reed's problem that she has as it relates to the non-announced alleged unanimous verdict on 2 counts. I've said this before when it all happened, but I'm going to break it down for you, all right? Jury says we're at an impasse. Everybody says we're at an impasse. Nobody bothers to ask, have you reached a verdict on any of the other counts? And I know some people say, well, the jury instruction said they couldn't do that. But no, they could have asked. They could have asked. And they didn't. So obviously the judge has immunity. The prosecution has immunity, but the only one that doesn't have immunity here is her defense team. So therefore, if the verdict in the second case comes back as a guilty verdict and she goes through all her appeals, and if she loses, her post-conviction is going to be that her attorneys, Mr. Jackson, were ineffective for not asking for judge to ask, have you reached a decision on all of the cases? And I will donate my time to say that that was ineffective, that any attorney worth their salt would have asked that, since the defense was the one asking for a mistrial. Remember, it was the defense saying, declare a mistrial, declare a mistrial now, declare a mistrial. Anyway, they didn't do that. When the ultimate question came down, they wanted the mistrial. Now they want their cake and eat it too. Karen Reed, I'm not going to donate my time or anything, but the reality of it is I would testify, if hired and retained as an attorney, that Mr. Jackson's performance fell below that of a reasonable practicing attorney when failing to ask if there was a unanimous verdict on any of the counts. And therefore, if she's convicted on any of those counts, her real remedy is to sue the attorney for malpractice. You watching that? Ms. Reed? That's it. And somehow, I think if it meant you not going to prison or you getting a chunk of change out of it, Ms. Reed, somehow I think you would sue the man that you think is the best attorney ever. we'll have to wait and see. Anyway, hopefully they have a jury next week. And I can't believe it's going to be 6 to 8 weeks of trial. Now, don't worry, we're going to bring it to you. We've brought you every moment of it thus far, bring you from gavel to gavel coverage on the Karen Reed trial. Next, Taylor Schabusiness. I know you're saying, where do I know that name? I've heard that name before. Taylor Schabusiness. You remember her. She's the woman that was convicted of chopping up her boyfriend. Yeah. Well, she'd probably do it again, but it was in the courtroom this time. This time, she just scowled furiously at her attorney before she hit him. That's right. Take a look at this video. Convicted murderer Taylor Schabusiness gave an evil glance at her defense attorney, Curtis Julka, before she jumped out of her chair and attacked him today. Now, footage from the courtroom shows court personnel jumping into action and tackling the killer before she did any more damage to her attorney. Anyway, Schabusiness was back in court for a preliminary hearing after she allegedly attacked a prison guard and got charged. Now, she is serving a life sentence without the possibility of parole at a correctional facility after she was convicted of killing Shad Thyron during a drug-fueled sexual encounter in Wisconsin. Now, the attorney, Mr. Julik, asked to withdraw from the case, but the judge said, nah, he had to finish the hearing first. Anyway, following a 45-minute bank, Schabusiness appeared at the hearing from jail via video rather than in person. Now, like I said, she had previously attacked her legal team back in February of 2023. She attacked her then lawyer, Quinn Jolly, during a hearing before a deputy wrestled her to the ground in court. Now, the outburst came during the proceedings to determine whether Schabusiness was actually fit to stand trial. Anyway, Schabusiness was determined to be fit for trial and was found guilty of homicide, third-degree sexual abuse, and mutilating a corpse back in July of 2023. Now, she was convicted of killing Thyron in his mother's basement, telling the court that she liked the killing and enjoyed cutting off her lover's head. She said, quote, I was sucking and cutting at the same time. Schabusiness says in a video, I liked it. I didn't know what to do. Anyway, prosecutor said that Thyron and Schabusiness had smoked some meth in the basement of Mr. Thyron's mother's Green Bay home before Schabusiness strangled, decapitated, and dismembered Mr. Thyron. She then left parts of the body throughout the house and in a car. Remaining calm, however, Schabusiness allegedly told detectives that after Thyron put the chain around his neck, which she compared to like a dog choke collar, she just went crazy and started strangling him. She said that she could feel his heart beating, so she kept pulling and choking him harder and harder, claiming that he would not die as he just kept rebuilding into muscle. Anyway, asked what she did once she realized he was actually dead, Schabusiness stated that she had played with his body. Schabusiness told detectives that he had planned to take all the body parts with her when she left in her minivan, but she had gotten kind of lazy and was ill-prepared because, you know, this murder was kind of random and wasn't really planned. Anyway, Miss Schabusiness attacking her attorneys, showing why she's a danger to the community, should never get out, probably fit to stand trial, just has some impulse control issues. Maybe that's it. Maybe just a little more social work involvement maybe would have prevented all of this. I don't know. Just having this conversation today. Some cases you feel more like a social worker than a lawyer, and I didn't sign up to be a social worker. You know what I'm saying? I don't know. Anyway, we have an update on the teen stabbing in Texas. Was it self-defense? Well, the teenager accused of fatally stabbing Austin Metcalf and leaving him to die in his twin brother's arms at a high school track meet allegedly admitted to the killing, but claimed, hey man, it was in self-defense. I'm not alleged. I did it. At least Mr. Carmelo Anthony, the defendant, understands affirmative defenses. I did it, but it was in self-defense. Anyway, he told that to the Frisco police department there in Texas as he was being arrested at the stadium. Now, the stabbing was sparked when Anthony, who was sitting under another team's tent as it had rained Wednesday morning, was asked by Mr. Metcalf if he could move. Mr. Anthony refused. Anthony then apparently unzipped a bag, reached inside, and told Metcalf, whom he'd never met before, touch me and see what happens. according to witness statements. Anyway, moments later, Metcalf then grabbed Anthony to tell him to move. Anthony pulled out a black knife and stabbed Austin once in the chest. Anthony ran away before he was chased down and arrested. He said, "I was protecting myself," is what he told the police. "He put his hands on me." He also then asked police what constitutes self-defense, and is Mr. Metcalf going to be okay? Well, anyway, Metcalf was a junior at Memorial High School outside of Dallas, suffered a stab wound to the heart, and died in the arms of his identical twin brother, Hunter. His brother said it was really like 30 seconds, this whole altercation. He said in an interview, "I never met this kid in my life. My brother stepped in and said, 'Hey, you need to move.' And Anthony's like, 'Make me move.' And all of a sudden, he grabbed his backpack, and there it was. It was over." I don't know, ladies and gentlemen. It's going to be interesting to see. I don't think that necessarily constitutes self-defense. Will you please move? But even if he puts his hands on him, the other guy's not armed, it's going to be pretty unlikely that you can retaliate with deadly force, even in Texas. Because I think even looking at you in self-defense, Texas is self-defense. But I say that kind of jokingly. But we'll have to wait and see how that one plays out. He is a juvenile, but he clearly can be charged as an adult, which will more than likely take place here in the next week or so. Yes, Young Thug. Remember him, the rapper who pled guilty to get out of jail, agreed to a very long probationary period. Well, he came this close to going to prison. So a judge in Atlanta has declined the prosecutor's request to revoke Young Thug's probation and send him to prison. But the judge cautioned him over his social media use after his viral post sparked an online backlash against the district attorney's office. Now, the Young Thug rapper pled guilty in October to gang, drug, and gun charges and then was ultimately released. The district attorney, Fannie Willis, said in a court filing Wednesday that he engaged in conduct that directly threatens the safety of witnesses and prosecutors, compromising ongoing legal proceedings and warrants immediate revocation of probation. But the Judge Paige Reese Whitaker, said in an order Thursday that she had reviewed Willis's findings and a response by Young Thug's attorneys and declines to revoke his probation. The judge said, "Well, the court does not find that the cited social media post rises to the level of a violation of defendant's probation. It may be prudent for defendant to exercise restraint regarding certain topics." Whitaker added in a footnote to her one-paragraph order. The judge said Young Thug reposted a social media post that included a photo of an investigator in the district attorney's office with a caption that said, "The investigator is the biggest liar in the DA's office." The post quickly went viral, had almost 2 million views, with thousands and thousands of comments. Anyway, the investigator's home address and that of her parents were posted publicly, and some posts included threats to the investigator and her family. One of the posts threatens the assassination of the district attorney, Miss Willis. "I don't make threats to people. I'm a good person," Young Thug posted Wednesday night on his social platform X. "I would never condone anyone threatening anyone, and definitely not participate in threatening of anyone. I'm all about peace and love." Now, the attorney for Mr. Young Thug said in court filing that the prosecutor's allegations were misleading and that the rapper hadn't done anything to violate his probation. Young Thug, who was given the name Jeffrey Williams, his government name, was indicted along with more than 24 other people back in May of 2022 and was accused of violating Georgia's anti-racketeering law. Now, the indictment said that the rapper co-founded a violent street gang that committed multiple murders, shootings, and carjackings over roughly a decade and promoted its activities in songs and social media. Whitaker gave him a total sentence of 40 years. The first 5 years were to be served in prison, but that was commuted to time served. Then he had 15 years of probation. Finally, a backloaded 20 years in prison will be commuted to time served if he complies with all the terms and conditions of his probation. Now, if the judge had granted the revocation of the probation, the 20-year prison sentence would have taken effect immediately. Anyway, prosecutors say the investigator whose photos Young Thug reposted is currently a witness in a multi-defendant gang murder case. And the judge explicitly said during a hearing that the investigator was not to be shown on television while testifying, and they're according to the court filings. A blogger posted the investigator's photo on social media with the caption, "She doesn't want to be shown on screen." Well, here it is. And Young Thug reposted it. Prosecutors wrote, Young Thug continued association with individuals actively involved in witness intimidation, threats of violence, and obstruction of justice is a violation of the condition of his probation, the prosecutors argued. His lawyers wrote that there was no suggestion the rapper was aware of the judge's order not to show that the investigator, and it's not a probation violation to repost an image on social media along with an opinion that the investigator is untruthful. None of these are direct threats as under the law, as his attorneys noted. Anyway, the trial of Young Thug and 5 others began in November of 2023. It took 10 months to get a jury. The rapper and 3 other defendants pled guilty in October. A jury in November found the 2 remaining defendants in the trial not guilty of racketeering, murder, and gang-related charges, but one of them did plead guilty to a gun charge. Young Thug, man, be careful. Mind your P's and Q's. I think anything related to the judicial system or gang-related activity probably shouldn't be reposting that at all. Somehow I think you got the message. I sure hope you do. Otherwise, you're a high rep learner and you probably deserve to go to prison. Next, guess what? Another teacher's been arrested for you know what, but this time with a twist. That's right. A teacher has been accused of sexually abusing a troubled inmate at a Kentucky juvenile detention center where she worked. And then she was trying to get the young kid to, I don't know, kill her husband? That's right. Anyway, the Adair County school teacher, Elena Barden, was busted after a routine search of a boy's room at the county juvenile detention center. And they found letters and other explicit material, and he allegedly been sent by the teacher, who was assigned to work there. Anyway, the evidence revealed that Miss Barden had subjected the juvenile to illegal sexual contact and provided him with sexually explicit images of herself. Now, police allege, without saying how old the boy was, the evidence showed that she had solicited the same boy to kill her husband. Anyway, Barden was arrested Wednesday and charged with solicitation of murder, as well as first-degree sexual abuse and distributing obscene matter to minors. Sending her pictures, sexually explicit images, is obscene matters. Anyway, according to jail records, she was booked at the Adair County Detention Center, where no bond has yet been set. The juvenile has not been charged with any crimes at this time. Doesn't sound like he agreed to kill the husband, not that he could have, because he's in custody. Anyway, it was unclear how old he was at the time of the lockup. Now, I don't know, ladies and gentlemen. Every day it's these teachers, and it seems to be more female teachers. Like, come on. And they're married and they're hooking up with teenagers. And I used to joke about it and say, why do all these, weird guy perverts, hanging out at schools getting charged with this? Because that's where the kids are, right? And now I got to say it about the teachers too, man. What are you doing? I mean, it's not like you all are ugly. You could probably go get a boyfriend, even if you're married, if you wanted to, I guess. But you choose to do it with high school boys and junior high boys? I mean, that's sexual assault. That's not a relationship. And now you guys are going to be sex offenders when you get out of prison. Something to think about. Next on the docket, this day in legal history. That's right, to April 4th, 1850, the city of Los Angeles is incorporated, setting the stage for its legal system and law enforcement structure, which would later handle, obviously, significant crime-related milestones in the United States history. On April 4th, 1905, the United States Supreme Court decided Jacobson v. Massachusetts, upholding a compulsory vaccination law, a significant legal precedent for public health and state police powers. Where have we heard that case before? A couple years ago, right? We can make you do whatever we want when it comes to getting a vaccine. And then on April 4th, 1968, Dr. Martin Luther King is assassinated in Memphis, Tennessee, triggering nationwide riots and prompting legal responses to civil unrest as well as hate crimes. Then on this date, April 4th, 1985, the United States Supreme Court rules in Tennessee v. Garner, limiting police use of deadly force against fleeing suspects. Obviously, some sort of a pivotal legal milestone in law enforcement. That's right. You cannot shoot people in the back when they're running away from you. You can give chase, but unless they're turning around and firing at you, you can't use deadly force. Imagine that. And finally, our dumb criminal of the day. And I'm telling you, every day we do our dumb criminal of the day, you think, God, people can't get any dumber. This dude is just felony stupid, ladies and gentlemen. Anyway, this Stephen Cusimano apparently became quite upset when he was denied a free refill at a lemonade stand run by children. That's right. Mr. Stephen Cusimano aggressively grabbed a female victim, adopted a fighting stance, and warned the victim that he was going to beat her up. Now, police say old Stephen was walking in the Clearwater, Florida neighborhood around 7:30 p.m. Tuesday night when he observed a lemonade stand being run by several juveniles. So what do, right? You go over and you help out the kids and you buy one glass for whatever they're paying for and you give them like $20 and you do the right thing, right? No, not old Stephen Cusimano. He purchased the one glass of lemonade and then became quite upset when he was not allowed to get a free refill in his cup. What does he think? He's at 7-Eleven or something? Like I said, then Cusimano then allegedly grabbed the victim by the wrist, got into a fighting stance and said, I'm going to beat you up. Cusimano then left the residential area on foot, but needless to say, the police found him quite quickly. During the questioning, Cusimano reported admitting to the entire sequence of events, but claimed that he grabbed the victim due to her talking shit to me. The complaint did not list the age of the victim. Cusimano, who police described as a transient, was charged with felony battery, an enhancement count due to Cusimano's extensive criminal history, which includes multiple convictions for battery, as well as convictions for trespassing, narcotics possession, disorderly intoxication, assault with a deadly weapon, theft, and disorderly conduct. Needless to say, the defendant, who's entitled to presumption of innocence, is locked up in the county jail, unable to make his $5,000 bond, but he has pled not guilty, ladies and gentlemen. So don't be a Mr. Stephen Cusimano. Like I said, do the right thing. You see a kid out there this spring, go over, ask how much the cup of lemonade is. It's probably $1, maybe 50 cents, whatever. And you give them $20 and you do the right thing. They're being young entrepreneurs just trying to earn $1. Do the right thing. Don't get mad at them and say, I want my free refill. Oh my God, Mr. Cusimano, you are our dumb criminal of the day. And once again, you may have taken the lead for dumb criminal of the year thus far. All right, everybody, that's all we have for you today. Thanks for watching. We'll see you next week. And remember, the Constitution matters.